Hi everyone. We've been getting a lot of questions about what to do when a family member is stuck overseas. We're in a time of a lot of crisis with everything going on with Russia and the Ukraine and general instability throughout the world. So this video segment is to talk about different options that you might have available to help a family member or loved one come over from overseas, either on a temporary basis or a more permanent basis. The following information is not intended to be legal advice. Every case is different, every individual and their circumstances are different. So if you're considering any of the options I'm about to discuss, I highly recommend that you contact an immigration attorney that you feel comfortable with to get the appropriate legal advice to suit your case. So in today's video, we want to specifically talk about people in the situation of having a family member or loved one overseas that they're trying to bring into the US, either on a temporary basis or a more permanent basis. So we're going to go through different visa options and various situations in which they might apply. So in terms of filing a family-based immigration petition for a family member, the first thing you'll want to determine is what immigration category does your family member fall into? And that's going to depend on a few factors, mostly your family relationship to that person and whether or not you are a US citizen or a lawful permanent resident. So there's a few scenarios in which your family member would be considered an immediate relative. If you are a US citizen and you're applying for your spouse, then your spouse would be considered an immediate relative. If you are a US citizen and you have a child under the age of 21 who is not married, then that child would also be considered an immediate relative. And finally, if you are over 21 and you're a US citizen, regardless of whether or not you're married, then your parent is going to be considered an immediate relative and you can apply for your parent. So anybody in those categories, again, you're going to be able to just file the I-130 family petition, and you're not going to be subject to what we call the visa bulletin, which is where there's a waiting period basically until you have a visa available. It's important to note that even if you're over 21, your parent is considered to be an immediate relative. However, if you are the parent of somebody who is over 21, and you are a US citizen, that relationship is not considered an immediate relative relationship. So it's a little bit confusing, but as a parent, your US citizen child could file for you once they reach 21, depending on certain factors and if they're eligible, but it just doesn't work the other way around. So it's a little bit confusing. Reach out to an attorney if you have questions on that. But generally that covers the categories of individuals that are going to be considered immediate relatives. Let's take a few examples of immediate relative categories. If John is married to Deborah and John is a US citizen and Deborah is not, then that would be an immediate relative situation and John could petition for Deborah in the immediate relative category. They would file an I-130 form, wait for that to get approved or to have an interview on that, and then they can move forward with consular processing, assuming that Deborah is abroad and John is trying to bring her here. So that would be a very common scenario for that type of immediate relative. For another example, let's say that Martine is a US citizen living in the United States and he has a daughter, Julia, who is 15 and living in Peru. Because she is an unmarried child under age of 21, Martine can file an immigrant visa petition in the immediate relative category to bring Julia to the United States. Now, say that Rebecca is a US citizen and she is 25 and living in the United States, and her parents never came to the United States and they are seeking to come here from abroad. Now, because she is over 21 and a US citizen, her parents would also be considered immediate relatives and she could bring them over. Now, conversely, if her parents were the US citizens and Rebecca was over 21 and was not a US citizen, her parents would not be able to file for her. So it's kind of a relationship that only goes one way for purposes of immigration. Now, in that context, she would not be considered an immediate relative, and therefore she would have a longer wait to be able to get her immigrant visa. So she wouldn't be in that immediate relative preference category. So it's a little bit confusing, but again, you want to think about whether your family member is considered an immediate relative if they fall into one of those 3 categories, or if they're going to be in one of the preference categories, in which case you'll have to pay very close attention to the visa bulletin. Have an immediate relative petition pending and an emergency comes up in your country or in your family and you need to bring that family member over right away, it's important to know that there are options to expedite that visa petition. So USCIS will take into consideration severe financial loss to a person or to maybe a company or a business, or urgent humanitarian reasons. And humanitarian reasons could be a lot of different things. They might be personal, meaning that perhaps there's an illness in the family or somebody needs an emergency surgery, or they can be global. So if you are in an area of high conflict, or if your family member is in an area of high conflict and they really need to get out of that situation urgently, or perhaps they're being threatened or harmed in their home country, that would be another reason to submit an expedite request. So if you think that if you have an I-130 petition pending for your family member, or you're about to file one and there's an emergency or some type of urgent situation, that would be a time to submit an expedite request. And if you need help doing that, you should seek the advice of an attorney that you trust who can help you submit that request to USCIS. So next I want to talk about the preference categories. So maybe you have a family member overseas, but they do not fall into one of the categories that I mentioned. I want to go through who you can file a petition for and who, there's no preference category available to file for, just so that's a little bit clear. And all of these preference categories are also listed in what we call the visa bulletin. So every month, the Department of State puts out a visa bulletin, and that lists all the preference categories, both for family and for employment. And it also shows what we call the priority dates. So basically, how long ago an application was filed that is being processed today, which will give you a rough idea of how long you will have to wait, depending on when your own petition was filed. So we'll talk about that a little bit later. But first, to go through the preference categories. So an unmarried son or daughter of a U.S. citizen is going to be an F1 preference category. So going back to the example of Rebecca, if Rebecca's parents are U.S. citizens, or if at least one of them is a U.S. citizen and Rebecca is unmarried and over 21, she would fall into that first F1 preference category. The next category is for spouses and children of lawful permanent residents. So if your husband or wife is a lawful permanent resident or your child, then that would be the F2A preference category. Fortunately, as of right now, there is no weight in that preference category. So even though it's not considered an immediate relative, it's what we call current, meaning that you wouldn't have to wait to move forward with that type of visa petition. Next is unmarried sons and daughters over 21 of a lawful permanent resident. So if you have your green card and you have a son or daughter who is over 21 but not yet married, they would fall into that F2B preference category. Next is F3, which is married sons and daughters of U.S. citizens. And sons and daughters meaning over 21. So if you have, in the example going back of Rebecca, if Rebecca were to get married and her parents were U.S. citizens, she would bump to the F3 category. And note also that there's no category for married sons and daughters of lawful permanent residents. So this is one instance where there's not going to be an option. In that case, you would have to wait for the parent to become a U.S. citizen, if that's a possibility, and then you would be in that F3 category. Otherwise, there's no category while the son and daughter or daughter remains married to give you an option to file for that family member. And last, we have the F4 siblings of adult U.S. citizens category. So people ask about this a lot. Can I bring my brother? Can I bring my sister? If you're a U.S. citizen and your brother and you're an adult, meaning over 21, then yes, you can start the process of filing for your sibling in most contexts. So looking at the visa bulletin for this month, there's an extremely long wait for most of these preference categories that I mentioned. Again, if you are a child, meaning under 21, or a spouse of a permanent resident, that category is current right now, meaning you can file the I-130 petition and then you can start your consular processing and take the steps to come to the United States. If you're in one of the other categories, there is a wait of anywhere from 7 to 24 years, depending on the category and depending on your country of origin, because certain countries of origin like Mexico, India, and China are subject to higher backlogs just because of the number of visas applied from those countries. So you can just Google visa bulletin and the current month if you want to have a sense of where those are at. And that would be where you would find that information. So one thing I want to note is that even if your family member is in one of these preference categories and the wait time seems like an unreasonable amount of time, it's often a good idea to file the I-130 now just to get it in. I've worked with clients over the years who get very discouraged and they don't file anything, and then that time passes anyway. So even if something's 5 years out, 10 years out, you can take steps in the meantime, but at least if you have that petition started, then you've kind of reserved your place in that waiting list. Let's say that you have the petition pending for your family member. Maybe it's not current, meaning there's still a few years to wait, and a situation erupts in your country or in the home country of your relative, making it very urgent for them to come here. Another form of relief to consider is called humanitarian parole. So humanitarian parole was used a lot recently to bring over many Afghan nationals who were in danger in Afghanistan once the Taliban took control. It is a temporary type of relief that basically allows someone to enter the United States for a set period of time due to an urgent humanitarian reason or for a significant public benefit to the United States. It's kind of an open-ended category, so it's a little bit hard to determine whether or not it's going to be approved in any given situation. But some things that are considered are, again, if there's an urgent humanitarian reason, that could be, again, war breaking out in your country or a specific family crisis or something going on that you can explain to USCIS that would be a reason for immediately needing to come to the United States. Now, some things that USCIS is going to look at when you submit that request are whether the circumstances are pressing, meaning how urgent is the situation, the effect of the circumstances on an individual's welfare and well-being. So, maybe if there's something going on in one's country, but it's not particularly affecting you as an individual or your relative as an individual, it wouldn't be considered as strongly as something that has a little bit more of a direct threat to someone's well-being. And then the degree of suffering that may result if the parole is not authorized. So all of those factors really just aim to get at the severity of the situation, the emergency of the situation, and whether or not it makes sense to grant this type of relief to an individual. And the second option, or the second consideration, is going to be if there's a significant public benefit. So this doesn't come up as often, but it might be, for instance, if someone's coming to the United States to participate in legal proceedings, maybe to be a witness in a case, or for a medical trial, if they're receiving medical treatment, but it's in a clinical trial that's going to benefit other people with that condition, or perhaps a healthcare worker during the COVID-19 crisis could even try this category, since it would be a significant public benefit to bring that person here. So again, humanitarian parole is temporary. It's only going to give you, I believe, 2 years in the United States, but for somebody who might have an option after that, or if they really only need 2 years to come here, then it could be a good option to consider. Or, if you have a family member overseas, there's significant turmoil in that country, and maybe you already have a petition pending, you might be able to get them in early with humanitarian parole while they wait for their visa to become available. There's also discretionary considerations. So if there's criminal issues or other problems, it could certainly be denied, but in many cases it might be worth applying for it to see if you can get the family member to come here earlier. Next, I want to talk about some temporary visa options for family members or loved ones overseas. So maybe your family member or loved one is in some form of danger or conditions are a little bit uncertain where they're living, but it might not be a permanent situation. So that might be a good time to look into temporary visa options to bring your family member to the United States from overseas for a specific period of time. So the first and most common visa to think about is going to be a tourist visa, which would be in the category of B1 if it's a tourist for business, or more likely B2, which would be tourism for pleasure. Once a B1 or B2 visa is issued, that person can travel on that visa for 6-month periods of time. So as soon as they arrive in the US, they're generally going to be granted 6 months to stay in the US under that visa. Their stay can be extended up to 2 times. So really that 6 months can turn into up to 1.5 years, depending on the circumstances. There has to be a reason for the extension, and you have to file a separate form called the I-539 to get that extension, but it can be extended in certain circumstances. So if you have a family member overseas and the situation doesn't look good and they want to maybe come to the US for a period of time, but it's unclear for how long, then the visitor visa is something to look into. You will have to check with your local embassy or consulate to see how long it's going to take to get processed and get an interview, but it's a good short-term solution to bring someone to the United States for a visit. Now, that's not to say that if someone were to come to the US on a visitor visa and then the circumstances change, maybe things in their country get worse and they decide to apply for asylum here, or another option becomes available and they change their mind and decide to apply for something later, that can also happen too. The important thing is that at the time the person arrives on the visitor visa, they are supposed to have the intention to remain only for a short period of time. So again, that changes very often later, but the relevant consideration is whether or not the initial entry into the United States is for temporary purposes. And if somebody is looking to come temporarily, but perhaps a little bit longer than the 6-month period of time, another option that often works well is a student visa. So particularly if somebody is already in college or in high school or looking into graduate school, that would be and if they want to leave their country, that would be a good time to look into coming as a student, which would be the F1 visa, and going through the process through their school. It's important to pick a school that is going to be helpful with that process. So certain schools routinely work with students. They might have an international student office at the school that can help facilitate the visa process. So look into the best program for that individual, and then make sure that the school can also submit the necessary paperwork to come on the student visa. I'll also just briefly mention that employment-based visas could be another option in certain circumstances. So if your family member or loved one has a job offer in the United States, that would be a great time to look into immigrant visa options in the employment category, or even non-immigrant visa, meaning temporary visas for business as well. And if they do not have a job offer but can demonstrate extraordinary ability, or basically that they're very high up in their particular field or endeavor, or maybe if they have certain high-level advanced degrees, there could be other options available to them. So in any of those situations, I would definitely recommend seeking out an attorney to discuss that in more detail, but business and employment can be another pathway to come to the US, either on a temporary basis or a more permanent basis. So to wrap everything up, if you have a family member who is stuck overseas and you're looking to bring them here, the first thing you're going to want to consider is whether or not they are an immediate relative or if they can fit into any of the preference categories. And from there, you can decide whether or not you would like to file a petition for them to come to the United States as a permanent resident. Secondly, if you have some sort of urgent reason to bring the family member here, then you might want to look into expediting your request, or if there's an exceptional circumstance, then humanitarian parole for a temporary period of time can also be a good option. So if you have any family members in that position, you should look into that. And if you have any questions, we're happy to talk with you one-on-one to see if that might be a good option for you. If you have a family member coming for a more temporary basis, or maybe they don't fall into any preference category, but they still need to come to the US for a set period of time, you might look into a tourist visa, or a student visa as some short-term options to get that person here and out of harm's way if there's any issues going on or if they're having any trouble in their home country. And then lastly, if employment in the US seems like a viable option, particularly if somebody has a job offer or if they can demonstrate a high level of education or skills, then employment-based visa options can also be available to that person. So that would be another situation where talking with an attorney is going to be really helpful to walk you through different options that could apply and what the process would look like for that individual. Thank you for listening to today's video. Please follow our Facebook and our YouTube page for more updates. And if there are any other topics that you would like to learn more about, please send us a message and we'll be happy to cover them in the next video series. Thank you.